So when you're sued by a company like Midland Funding, Midland Credit Management, Portfolio Recovery, LVMV, one of the first questions that will come to mind is this even legal? Is this proper for Credit One, Synchrony Bank, some other bank to sell my debt to a debt collector? So it's a very legitimate question to ask. Here's the answer. It's probably not the answer we want to hear, but at least in Alabama, where I practice and have been for 28 years and defended, I can't tell you how many people sued by these companies. The answer is yes, it is legal to buy and sell, for example, credit card debt or car repo debt, things of that nature. But here's the more important question. Okay, I know Midland can buy a debt. I know Portfolio Recovery can buy a debt. LVMV can buy a debt. But did they buy the debt? Okay, they're suing me saying, hey, we bought this debt. Here's your debt, John. We bought this debt and we're suing you for it. Now, see, if I come into court and go, Judge, my entire defense is it's absolutely illegal for them to buy debt. Judge goes, well, you're wrong, so you lose because that was your only defense. But instead, I come in, and when they sue me and say, hey, John, we bought that old Credit One or Synchrony Bank debt, I go, prove it. Prove you bought it. They go, well, we bought it. I go, well, I understand you say you bought it. I understand that you put in a lawsuit you bought it, but now we're at trial. Prove it. Where's your evidence? They go, well, I mean, we did. We bought it. This is the lawyer. You go, well, we wouldn't have brought the lawsuit if we didn't buy it. I go, well, it's not a question of would you have brought the lawsuit, not brought the lawsuit. Question is, we're in trial now. Where is your proof you bought the debt and that you still own the debt? And they'll say, oh, well, let's see. We've got a bill of sale. It's a one-page piece of paper. It says bill of sale. And we look at it, we go, well, actually what it says is that this is part of the credit card purchase agreement. That's a document that has all sorts of rights and obligations and disclaimers. And, it may say, hey, we do not claim that any of the information we're selling you, Midland or Portfolio or LVMV, is remotely accurate. We go, where's that document? They go, oh, that is super secret. We could never let you see that document. Just go with this bill of sale. We go, no, we want the whole document. It's what in most states, at least in Alabama, it certainly is called the completeness doctrine. If one party introduces part of a document, the other party can say, hey, let's introduce the rest of the document. Really important in these purchase agreements because a lot of times the purchase agreement will say, all the stuff we're selling you and we're saying this is what the person owes and here's the document. Yeah, we don't promise any of that is remotely accurate. And sometimes the lawyers will say, well, Judge, that's outrageous. Why would they put that in there? Well, let me give you an example. Let's say you've got I don't know, what's $100,000 car, like a Mercedes or something. There's some car that costs $100,000. If you're walking down the street and somebody goes, hey, buddy, come here in the alley, say, look, I got this car. It's a little used, but it still works great. It's a $100,000 car. If you go down to the dealership, I'll sell it to you for $5,000. 5%. It's about what debt buyers pay. And now, do you expect that person to give you some great warranty and they're going to just promise you everything is perfect? They're going to be like, no, you're buying it as is. You say, well, the alley example's silly. Okay, well, let's imagine we're at a car dealer, used car dealer, and there's a $100,000 car. They're selling it for $5,000. Do you think they're giving you like a full warranty, a legitimate warranty? Of course not. They're going to say, hey, you take your chances, man. You're buying a $100,000 car for $5,000. If any of it, if it works, if it doesn't blow up as you get half a mile off the lot, hey, yeah, that's like bonus territory. So again, keep this concept in mind. There's different ways to get to it, different ways to force the debt buyer to prove it. But don't fight the wrong battle. Don't fight the battle over it. It's wrong that they're buying and selling debt. That's immoral. That's illegal. You know what? It's not illegal. And frankly, it's not immoral. I can sell this, I can sell a car, I can sell any kind of asset, okay? Unless there's some specific law about it. Instead, focus your energies on, and obviously you represent yourself, you got to make your own decision. This is what we do. Focus our energies on, can that debt buyer prove that this particular debt that it claims to have bought, can it prove it really bought it? Can it prove it owns it? Not just that I owe the debt, but that it owns the debt. And that has been the basis of tremendous success we've had over many, many, many years. And it's not a secret. We first put this out in a blog post, I want to say in like 2007, maybe 8. And it kind of went viral, but where we say, hey, it's not just do you owe the debt, it's does the debt buyer own the debt? That's been around for 15 years. I've given countless, presentations on this. It's not a secret. It's what they struggle with, okay? So anyway, I hope this is helpful to answer that question. Is it legal to buy and sell debt? Yeah, it is. But more important, focus on, does that debt buyer actually own the debt that it's suing you for? Okay, guys, I appreciate you watching this, and let me know if you have any questions or comments. If you're in the state of Alabama, reach out to my law firm, alabamaconsumer.com, and we'll talk to you later. All right, see you in the next video. Bye-bye.